Please be seated. Court now calls case CV12 709, Clark versus Monarch. This is the time set for oral argument. Counsel, these proceedings are being audio recorded and video recorded, so I want you to understand that the link to the video and audio will be on the court's website in a few days. Keep that in mind as you make your presentation. Please identify yourself and your client when you get up to speak. You each have 20 minutes. Keep track of your time. Counsel for appellant, you may wish to reserve some time for rebuttal. I will advise you we've read your briefs and we've conferenced the case, so we're very familiar with the case. And I would also note that the clock on the podium in front of you will help you keep track of time. That being said, counsel for appellant.
Thank you. Excuse me. Thank you, Your Honor. I'm Thomas Payne for the appellants, Monarch Payne, Inc., and Thomas and Barbara Payne. I would like to reserve probably 5 to 7 minutes for rebuttal. In the early 90s, we're going to be, my argument today is going to be relating to the exclusion of vital evidence pursuant to Rules 37C and 26.1. And in the early 90s, shortly before 26.1 came into effect, the Arizona appeal courts, led by the Supreme Court, began to put in place, as you're very aware, ground rules for enforcing 26.1 to try to keep abuses at a minimum, as sharp lawyers tried to win bad cases by laying in the weeds and pouncing on disclosure lapses, and some trial courts were all too eager to dismiss cases for violation of the rules. One of the earliest cases was Allstate v. Toole, a 1995 case, in which the Supreme Court restated the principle that procedural rules must be interpreted to maximize the likelihood of a decision on the merits of a case, and that attorneys are to avoid gamesmanship and not try to trip each other up over technicalities. Further interpreting Allstate, this court in 2003 ruled that a court must afford a heightened level of due process when the effect of discovery sanctions is to effectively terminate a case or exclude vital claims or evidence. It also ruled that the trial court's discretion in dismissing a case for discovery violations is more limited than when it employed lesser sanctions. And this is Zimmerman v. Shakeman, a Division I case relying on Allstate. The case before you today is a poster boy for the type of attorney behavior and judicial indiscretion that both Allstate and Zimmerman warned against. In the incident case, faced with a strong case against them, the law firm's attorneys have repeatedly sought to strike all critical evidence and witnesses, and the trial court consistently violated statutory and case law to levy the maximum sanctions available, with the result that the sanctions that were leveled pursuant to 37C terminated the appellant's case almost immediately after they were ruled.
Mr. Payne, weren't you and your clients put on notice approximately 2 months before the trial that no witness testimony would be permitted if that had not been fully disclosed?
It was, Your Honor, but there was no the witness testimony that was excluded was both that had not been disclosed and that had been disclosed. There was a portion, as I will go through, of the expert's testimony that had been disclosed. He had written 2 opinion letters.
Well, plainly, yes, he had his written 2 opinion letters, which we're aware of, and also he had his deposition taken. But isn't it true that in his deposition, he was asked whether he had reviewed additional documents, accounts payable documents, and he said, "No, I have not. I'm going on the assumptions. I'm going on the information that's been provided to me."
No, Your Honor, that's not the case. What had happened was that there were 2 documents that were very key to the case that had been obtained by the defendant or by our side after the depositions by the expert witness concerning the documents he had received before. These documents were, of course, turned over to the other side, and they were reviewed by the expert. The expert looked at them and said, I don't change my mind. These do, and he testified later to this at the trial. These do not change my opinion. They simply reinforce it, and therefore he stated, and I agreed with him, that a Rule 26.1 disclosure letter was not required since it did not change his opinion. Now, we got to court, and he mentioned that he had asked for these documents and had reviewed them. It was at that point that the court, that the other side jumped up and said, we object because we didn't know that he had reviewed those documents. We had never said that he had not reviewed them. At his deposition, he had not reviewed them because they had not been obtained yet. So, and there was no deposition after that.
Yeah, that was my question. He had been asked that question at deposition, so wouldn't it have been incumbent upon you and your clients to supplement those preliminary expert opinion affidavits, or file a supplemental disclosure saying, I'm now relying on these additional documents that I've now reviewed in support of my opinion?
He was not asked the question, have you reviewed these documents, because those documents at that time of the deposition were not known to exist.
I understand that.
Therefore,
didn't that fact right there put you on notice that you needed to supplement his disclosure?
yeah, there is an argument, and I will concede that they should have been disclosed, and it was technically a violation of 26.1.
So yeah, that's what the point I'm trying to get to here is you're not contesting that it was actually a violation of Rule 26.1. What you're saying, it was too harsh of a sanction.
I actually, in my brief, I do contest it was, but even if it was, I'm saying that the sanctions that were levied as a result of that were against both the statute, the language of the statute that was used to exclude the testimony, and also against the prevailing case law as to how to handle sanctions that kill a case, because this one killed a case.
Counsel, how is it not a violation of 26.1? You had some documents, your expert read them, reviewed them, the documents reinforced his opinion, and he was going to testify at trial that they reinforced his opinion.
He was only going to testify that he had reviewed the documents and did not change his opinion. The documents themselves, which were not in evidence at the trial, by the way, they were not in evidence at the trial. The documents themselves were not going to be. He was not going to testify as to those. They were supposed to have been before they were also excluded. These documents were excluded prior to the trial. They were going to be brought in. All of the facts on those were going to be brought in by another witness, a fact witness, to show what the documents were and why they were and so forth. The only testimony that the lawyer was going to say, and he said this at his voir dire, was he was going to say these documents reinforced or validated my opinion that I had reached before. They didn't change it in any material way.
Here's where I get confused. The court ruled that your expert could testify to the documents he had at his deposition. This is what I understand. And he couldn't testify about the new documents. That's the ruling that we have. And then you asked him with the very next question, a question pertaining to all the documents in the case. So by your question, you violated the court's order in seeking an opinion based on all the documents rather than just the documents that he had testified to at his deposition. And what I'm hearing you say today is he didn't really need the new documents. He had an opinion based on what he had reviewed at the time of his deposition that was sufficient. So
that's correct. I didn't need I needed the new documents, but I didn't need it for this expert to testify about the new documents. I had other experts before the documents were, not experts, but other fact witnesses that would have brought all of the documents into case. The court did not rule that he could testify about everything except the new documents. The court ruled that he could not testify at all, and they eliminated him as an expert. As soon as they eliminated him as an expert, he was gone. I couldn't bring him up to testify about the documents that he had reviewed prior to his deposition, and because I didn't have excuse me, because I didn't have an expert, I was unable to satisfy the statutory requirement of a standard of care expert, and therefore the case was terminated. It was terminated specifically because I couldn't get his testimony on the record that he had disclosed a year or so before, which was strong testimony. It just wasn't as strong as it would have been with these new documents.
Counsel, so I'm a little confused about the record. My understanding was that when an objection was made to Mr. Dodge's testimony, the court ordered that Dodge was prohibited from discussing his review of the accounts payable documents, the documents at issue, and any other evidence that was not previously disclosed, but permitted Dodge's testimony proceed. You then asked Dodge for his opinion based on all the documents he had reviewed.
That's not accurate, Your Honor.
That's not accurate?
The record would show that what happened was I asked very early, after we got through qualifying him as an expert, I asked him what he had reviewed in order to make his opinion, to reach his opinion. I'd asked him if he had reached an opinion. He said yes. What did you review to get to that? He talked about other documents and so forth, and he mentioned that he had also asked me to obtain other documents that had not been had not been available at the arbitration, so he could review those. And at that point, I didn't ask him any questions about those. At that point, that's when the objection occurred. There was no more questions in front of the jury of Mr. Dodge. The rest was voir dire, and at the end of it, the judge said he could not testify at all, and he was dismissed as a witness. I never asked him any questions about any of the documents themselves beyond what he had reviewed, and he stated that.
But at voir dire,
voir dire was outside the jury, of course.
I understand that.
Yeah.
Yes, thank you. My understanding was that Mr. Dodge was asked, were any of the opinions you intend to offer today based at all upon the records or the documents Mr. Payne provided to you since the time of your deposition? Yeah, most of them, yes.
Right.
And then Mr. Dodge admitted that in preparing his opinions for trial, he didn't make a distinction between records that were produced before the deposition or after the deposition. Is that accurate?
No, I don't think that's accurate, Your Honor. In terms of the facts of the case were that he had reached an opinion that there was a breach of standard of care here, and he had done that based on documents that he had reviewed well in advance of receiving these new documents. In the voir dire, he was asked specifically, what did you want to do? I didn't ask him any questions about him. He volunteered it. He said, I asked him, what did you want to do? He said, all I wanted to do was to say that I reviewed these documents and they verified my opinion.
But you're saying that the Clark law firm didn't ask him, were any of the opinions that you intend to offer today based at all on the records or documents Mr. Payne provided you after the deposition? And he said most of them yes. That didn't happen. Yes,
he did say that. Later on in voir dire, though, he also stated several times, did your opinion change as a result of these documents? And he said no, they merely reinforced it. I argued in voir dire that he should be under 37C which states that only evidence not disclosed should be excluded based on a violation of 26.1.
Oh, did
That-
you ever offer to the trial judge saying, well, gee, Judge, I'll just ask him,
I
based
did.
on the documents that you reviewed at the time of your deposition, what's your opinion?
I did. I asked that several times, and during the voir dire, I offered that on many occasions, several occasions, and he was disclosed. His opinion based on everything except these excluded documents was disclosed, and he should have been able, pursuant to 37C, which specifically states only that undisclosed document evidence must be excluded. In addition, the understanding, we're talking about a decision that knowingly kills the case, which under Arizona law requires a higher level of due process. There were other there were other options available.
What were those?
One was, of course, to allow his deposition to go forward on the disclosed information as was actually required under 37C. But there was another one.
To have a deposition in the middle of trial? Well, I'm sorry, I misunderstood. What was the alternative? To offer his deposition?
No, that's the second alternative. The first alternative is to allow him to testify as to his disclosed information without reference. Okay. Now, the second was, another one, was that the judge could have stopped the proceedings. This was a Thursday afternoon. Judge could have stopped the proceedings and allowed a deposition the next morning because the court had already announced to the jury that Friday was going to be an off day. They were not going to be back for reasons of the judge's schedule, and that they would be back in court then on Monday. So the court could have easily, if it had wanted to abide by the
Counsel, let me ask you this. I understand. You're suggesting they did do a deposition in the middle of trial. Did the opposing counsel object to the deposition testimony of your expert? They took a deposition of your expert. They didn't object to the opinions that he rendered in that in terms of timeliness of disclosure, correct?
They didn't.
Why didn't you offer the deposition testimony?
They stated, and the judge bought, that the failure to disclose the excluded documents, that his review of those was tainted the case so much, and that he was not going to be. They objected to his testimony about the disclosed information. I said that doesn't make any sense. It's a bizarre ruling if you think about it. We're talking about their reason for not wanting or for objecting and saying that they were harmed. If they weren't harmed, of course, 37C doesn't apply anyway. But they were saying they were harmed because they could not. They were not able to depose him on the excluded documents.
Well, nor had their own expert, to the extent they had one, their own expert was not placed on notice that Mr. Dodge would be relying on those documents.
That's correct. That's correct. However, so the court decided to kill the case based on failure to be able to depose on documents that were not in evidence. These documents were not in evidence. They were never going to be mentioned by anybody. They were not in evidence. They had been excluded in another, I think, violation of discretion, but they had been excluded by the judge prior to the trial. So they were not there. There was not going to be any testimony about those documents. I couldn't testify. I couldn't ask the expert about those documents. They were not in evidence. They had been specifically excluded. I knew that. Everyone knew that. And there was certainly not going to be any cross-examination of that witness on those excluded documents, which would, of course, open them up to be entered into the record. They had worked very, very hard to get those out because they were devastating smoking gun type of documents that would have, we believe, made the case.
If they were smoking gun, but you weren't going to use them, I don't understand. I mean, if the
couldn't use
expert
them.
wasn't going to say anything about them, then why?
We couldn't use them, Your Honor. They had been excluded. I would have been up for sanctions, I assume, because they had been excluded in a pretrial motion They could not be introduced. They could not be anything. I was not going to ask Mr. Dodge about those documents. I couldn't, because they were not in evidence.
What led to the initial objection then?
The thing that led to the initial objection was the court believed that they could talk the judge into excluding this witness in its entirety, and therefore killing the case, which is what happened. As a result of that, within 10 minutes, the counterclaim was dismissed, and the next day, because
I understand. I'm just talking about the initial objection when counsel stood up. But that's okay. I understand. We can look at that.
well, I'm running out of time, so I'll answer any questions that you have.
I've got a question for you.
Sure.
Mrs. Payne, the community property issue.
Yes.
She was found liable for the fraudulent transfer?
She was found liable on all counts.
She was sued for breach of contract?
No. She was sued only for, there were two suits, or three suits. One suit was against the corporation for fees.
Right.
That did not involve the individuals.
Right.
Then there were two suits against the individuals trying to pierce the corporate veil. One for quantum merit and one for fraudulent transfer. She was found, as all individual defendants was found guilty on all of those. And
when you say all of those, you're saying that she is found liable on quantum merit and on fraudulent transfer?
That's correct. And she was found, she was found, and this is another argument which that we have, that was not valid because the court refused to allow jury instructions about Arizona property law that could have precluded her community.
But if she's liable on fraudulent transfer, I mean, as I understood, you're saying she can't be liable for the debt of the corporation or your debt unless she agreed to it. But if she's liable for fraudulent transfer, doesn't that moot that argument out? Because the fraudulent transfer would mean that she had participated in the fraudulent transfer of funds so that the Clark law firm couldn't.
There was evidence that she had not participated in it.
Or was there evidence that she had?
No. In my opinion, there was not.
And you argued that in your brief?
Yes. Well, we argue the brief that the jury could reasonably have found, because the community property would not have been liable to any claim in the arbitration under two statutes. Therefore, the individual individual defendants did not benefit from the law firm's representation in the arbitration, and therefore.
I understand that, but the claim for fees was a suit against the corporation, MPI.
That's right.
Saying you didn't pay our fees.
Right.
Pretty simple claim. Mm-hmm. Didn't pay our fees, you owe us some money.
That's correct.
And the claim, and the law firm's claim against Mrs. Payne was you participated in a fraudulent transfer, so we couldn't get those fees. We couldn't obtain money. Is that fair? Is that a fair summation of what they argued?
Yes, against all of them, right.
And the jury found against Mrs. Payne on that claim.
Right. The jury. Well, if you there are other extenuating things in our brief that I won't mention those, so I'm out of time. But anyway.
But they did find her liable on the fraudulent transfer.
They did find her liable. There's no issue there.
Okay. Thank you.
Thank you, counsel.
Is that it?
Yes, that's
okay.
it.
Thank you.
Do you want a couple more minutes, counsel? I think we went over a little bit.
Sure, we'll reserve that. I don't know.
Let's see how it goes. How about that? Okay.
What's that?
Well, let's see how it goes. How about that?
Thank you. And I'm Brian Purcell, representing the Clark Law Firm in its capacity as a counter-defendant. Mrs. Clark is here representing them in their capacity as a plaintiff. So, to the extent representing the law firm in its capacity as a plaintiff, so to the extent that questions start coming up about that, we might switch off at that point, if that's okay. I think the key issue here, the only real basis for this counterclaim were these AP documents. And under 26.1, they were required to disclose the grounds for their experts' opinions. Those were never disclosed. We didn't have a chance to, and it was about 1,000 documents. These aren't just, it's not just a couple of pages of things. These were fairly complicated accounting documents.
And we can double check this, but is it your recollection that during the voir dire of Mr. Dodge, that MPI said, well, we'll offer his testimony only on what he's reviewed at the time of his deposition?
I believe that they mentioned that, but and he also he testified very clearly, and there's about a 60 or 70 page voir dire here,
Sure.
And that was consistent with Judge Cooper's. I mean, she gave every opportunity through this entire case to allow him to comply with his disclosure obligations.
Counsel, here's the confusing thing. We read this record, or there's one way to read this record, that an objection was made to untimely disclosure of an expert opinion, specifically opinions based on new documents that had never been disclosed, or opinions, I want to be clear, on those documents. And so your client objects at trial, says, objection, Your Honor, these opinions haven't been disclosed. And so then there's this long voir dire, and my understanding of the record was that the trial judge said, you're not allowed to testify as to any undisclosed opinions that you've arrived at based on these records, but you can testify to anything that you have previously disclosed, specifically what you testified to at your deposition. Is that what happened?
I don't think that's exactly correct.
Okay, what happened?
What happened is, during his voir dire, he was asked immediately what his opinions were based on. He testified they were based in great part on the AP documents. Now, there was no way they were ever going to be able to make their case without him testifying about those AP documents. That was the entire crux of their counterclaim. When they start talking about other opinions he may have had and these sorts of things, that's just not supported by the record. His opinions were that supposedly not introducing these AP documents caused some damage in the underlying arbitration. Now, we disagree with that, and we laid that out, and that might get a little bit confusing when we talk about that. But the fact is, the arbitrator found that those documents would have been cumulative anyways. But there was no claim without him testifying about these AP documents, and without us.
Well, wait, I'm looking at the May 10th voir dire. And Mr. Payne says, Your Honor, he will be providing testimony based on his two. From this point forward, I would like to go further, but I won't. He will be providing testimony based on his two opinion letters, both of which have been disclosed a long time ago. Doesn't that take care of the problem?
No, because those opinion letters were based on assumptions he had made about AP documents that he had never seen,
Well, but
and we had no opportunity.
Right. Oh, of course. But he's not going to refer to the AP document. At that point, isn't Mr. Payne saying he's not going to refer to the AP documents?
He had to refer to the AP documents. How he couldn't testify that introducing the AP documents would cause damage without referring to the AP documents. And on top of that, I don't know how the bell would have been unrung, in essence. Yeah, he's talking about how these documents allegedly not introducing them cause damage without referring to them. He's telling the jury that. I mean, how is the jury going to make that determination?
But if he said in his deposition that I assume that these AP documents would show the following, you could then cross-examine him, and I assume you would and did, that, well, you've never seen the AP documents, so you don't know, do you?
And we did cross-examine him in that fashion
And that would
at
go to
his
the jury,
deposition.
and that would go to the jury. And so the jury would hear his testimony of his opinions on, without looking at the AP documents, and then that he never looked at the AP documents, so he didn't know. So couldn't the judge, I guess where I'm going towards is, couldn't the judge have let Mr. Payne, Mr. Dodge testify as long as he was asked, tell us about the opinion you rendered at the time of your deposition?
I don't believe she could have. I mean, the entire grounds for his opinion, which is required under 26.1, were these AP documents. Without them being properly disclosed, There was no way for him to adequately or properly testify as to them, and there was no way for us to cross-examine him on those documents.
Counsel, you're talking about a foundation or relevance issue versus a disclosure issue. What was the basis for the court precluding this expert? Was it a discovery violation, untimely disclosure, or was it lack of foundation? Because the opinions rendered at the deposition didn't have proper foundation because he was talking about documents he'd never seen.
I believe it was both. I think it was primarily a disclosure violation. And the other issue, I mean, under Rule 37, there was never any attempt made to establish what kind of good cause there was for not timely disclosing these things. I mean, it just came out at trial, and it was almost, I don't know that he intended it, but it was kind of an ambush. We had no idea that he had reviewed these. It would have taken us a week or two at least to have our experts review them. We had an accounting expert. We had a lawyer expert. It would have taken us a long time to go through all these thousands, or not thousands, but about 1,000 documents to prepare for any sort of cross-examination. And I don't believe there was any attempt to comply with, I think it's 37C4 or 37C2, which requires you to show good cause for why things are disclosed late.
Counsel, I wanted to make sure I understand the record correctly. There was an initial objection when Mr. Dodge was explaining the basis of his opinions, and he referred to the accounts payable documents, correct?
Correct.
Good. And then counsel objected, and there was some discussion at sidebar, and then my understanding is that the court then said, opinions that have not been disclosed, or the basis of the opinions that have not been disclosed will not be allowed. And then Mr. Payne resumed examination, at least for one question, I believe I thought, or a question or two, and that's when the question came up, based on your view of all these millions of documents set forth, did you form an opinion am I understanding the record correctly?
That's correct. I mean, what happened is she said, you can't go there, and then the expert couldn't really say anything without going there, and so he immediately went back to that issue, and that's when
And then what happened after that?
Ultimately, the judge determined that he couldn't testify because his opinions were clearly based on, they had to be based on these AP documents. There was no other potential basis for certainly causation opinions, and that was the essential ruling. I also want to make clear, this is there's sort of something running through the briefs that Mr. Payne was a little bit unschooled or something of that nature, but he is a licensed Arizona attorney. I just want to make sure that we realize that this isn't. I know pro pers they're not supposed to get additional consideration, but I just want to make sure that this isn't a pro per. Make sure it's clear that this isn't a pro per situation. And I think the other important issue, and it was brought up during his argument, is that there was a motion in limine filed, and I don't believe it was even opposed by the plaintiff or by the counterclaimant regarding undisclosed opinions of Mr. Dodge. This was on the table. Judge Cooper held, I believe, 3 or 4 pretrial conferences on various issues in the case. There was no. This wasn't sprung at the last minute or anything like that. It was very open. Everything was out there. The same is true with respect to Mr. Monak's testimony about the AP documents. That was always out there. Judge Cooper allowed the counterclaimant to give us, I believe, I think there were 18 pages of his proposed testimony. So this was, there was never a request for a trial continuance. There was never really, I mean, these things were always out there. He had the opportunity to correct the problems that were very evident, and that was never done.
Counsel, let me go back to this business about what happened during voir dire. I'm assuming that your argument is premised on the following. A question to Mr. Dodge at page 135 of the transcript. But in any case, right now, if you were to offer opinions today, they would not be based upon assumptions of what documents might show, but would rather be based upon having reviewed the documents, meaning the AP documents, and what you believe they would show, correct, or believe that they show. Would that be a fair statement? Answer, that I know that they show, yes. That's the premise of your argument, that he couldn't go forward without saying, with his opinions, without saying what the document showed.
Correct. That's correct, because anything he said before was essentially speculation. Anything he said at his deposition about what he thought they might show was speculation, and for him to testify.
But even if it wasn't and it was admissible, the problem, it seems to me, is that Mr. Dodge is now saying, I can't differentiate between my earlier opinion and my later opinion because I'm going to tell you what the documents show.
Right. I think that's correct. And as I mentioned, we had an accounting expert and a lawyer expert who certainly would have testified if given the chance that these documents didn't establish any sort of causation. And I want to keep coming back to that. This is a causation issue, which is a critical element of a malpractice claim, and they just didn't have any evidence to show that because he didn't have well-grounded opinions, and that's why the directed verdict was proper. And I've yet to see anything else identified, any alleged breach of the standard of care identified, not related to the AP documents that could have allegedly caused any damage.
Did you ever file anything pre-trial to strike the expert? The deposition testimony you had was not admissible. Sounds like what you're arguing. The expert was testifying about what he thought the records would show, and if they showed this or they showed that, then he could reach these conclusions. If I characterize that properly?
To the extent he was arguing that the AP documents should have been introduced and that would have caused a different result, those would have been not well grounded under Rule 26.1. So I think the answer is yes.
So prior to trial, with what you had, what had been disclosed to you, you had an expert who was giving almost a hypothetical opinion about what he thinks the documents would show, and he never did follow up with a disclosed opinion about what his review of the actual records showed. Is that fair?
Correct. I would call it hypothetical and speculative about what his opinions were regarding those documents. And that's why the motion in limine we filed, which I almost thought was, we were almost going one step, I thought, above what we really needed to do, because I think it's pretty clear you can't introduce new opinions at trial. But we actually filed a motion in limine to make that issue very clear and to put it in front of everybody that things undisclosed weren't going to be proper at trial. And we filed that about 60 days before trial. As I mentioned, there was no request for continuance, nothing like that. It just that was out there. I just wanted to touch briefly on the. I don't have much time left. I don't know if you guys have questions on the on her portion that she's going to argue, but I just wanted to touch briefly on Monak's testimony. That was also an issue that was out there. The Smith-West documents, it could have been, all that had to be done was to get somebody from Smith-West saying these post-closing documents mean this. That wasn't done. Mr. Monak, the testimony was he was frozen out after the sale that happened in February 2007. While he did continue working for the company, he wasn't. The company changed their system, and it would have just not been possible for him to testify about those documents. Maybe more importantly, it would have been very easy to get somebody from Smith-West to testify about what those documents meant. And then coming back to an argument that we do go through in our brief to some degree, and I won't belabor it, but the arbitrator ruled that those documents would have been cumulative in any event. So there was really no way for Mr. Monak. He just wasn't the proper witness, and it would have been easy to get someone from Smith West in, and for whatever reason that just wasn't done. And if there are no further questions for me,
Any questions? No? Thank you, Counsel.
thank you, Your Honors.
See, you didn't need that extra time after all.
Well, we
No,
still
I
have
don't-
Ms. Clark.
Oh, Ms. Clark, I'm sorry. Oh,
Sorry.
no, you're right. Not that I don't want to hear what you have to say, Ms. Clark. I'm waiting.
Good morning. I'll just make a few comments and then answer any questions you have. Obviously, I've been following the arguments so far, so I'll just make a few comments on those because I was there at trial and I have a very strong recollection of the issues and what occurred at the time. First of all, just to follow up in regard to the voir dire and the issue about whether Mr. Dodge could split out in his brain what his opinion was prior to reviewing the thousands of pages of accounts payable information versus his minimal opinions based upon speculation and an assumption of what he would see if he ever saw those accounts payable documents. It was brought out quite correctly here as to the fact that it was not possible for him to split that information out. It was just an impossibility. And your questions have basically brought that information out. But I want you to understand that this was a judge who was very careful. I have never seen a more thorough and careful judge in my entire career. She did 3 pretrial conferences. She gave the defendants and counterclaimants multiple opportunities to fix the errors that they were making as far as failure to disclose, failure to get the necessary witnesses. They dropped one of their witnesses, an expert witness, at Mr. Davis with, no apparent reason, causing themselves further problem. So they made mistakes, and then they had put themselves in sort of a box. So Judge Cooper gave them opportunities to pull themselves out of that box to the extent possible. So she did have in mind getting as much before the jury for purposes of deciding this on the merits. But again, as to Mr. Dodge, he truly could not split out in his mind what he had done originally, which was pure speculation, and what he had concluded after reviewing the thousands of pages of documents. In response to the point about how the questioning and then cross-examination of Mr. Dodge would occur, if it had been presented based upon his 2 opinion letters, quite frankly, it would have been very easy for our side to point out that it was based on speculation, and therefore it was not a solid opinion and it's not meritorious. So that was the plan, and certainly that would have been successful if we had not been surprised at the last minute that he had reviewed documents and he had failed to, the other side had failed to disclose that and had failed to provide a supplemental opinion letter. This is particularly important because those documents, as Mr. Payne argues, were very vital to his case. So he should have exercised excellent care as to getting them into evidence and then making sure that his expert fully disclosed what effect, if any, that review had, and also some facts about why those documents provided more than mere speculation. As to the other topic here, as far as a reference to the case against Barbara Payne, the final admission by Mr. Payne here was correct. His final admission is, yes, she was found liable on the fraudulent transfer. So just in and of itself would have been sufficient basis for the conclusion of Judge Cooper regarding the liability of Barbara Payne.
So the community property issue is mooted out by that? Is that what you're saying?
Absolutely.
Because she's liable personally for the
Absolutely.
fraudulent transfer?
She herself, an experienced attorney, had her signature all over those documents. She was an integral part of that fraudulent
There have
transfer.
been evidence back and forth, but the jury did find her liable on that issue.
Precisely.
And the damages on that were the same as the breach of contract and the quantum mirror.
You are absolutely correct.
Okay.
All right, counsel, I think we've pretty much run out of time. Did you need an extra few seconds to say something else, or?
No, I'm fine, thank you.
All right. All right, we'll take this matter under advisement, and we'll issue a written decision in due course. Court's in recess. Please be seated. This is case CV12 859, Barunda Beltran versus Rico. Time set for oral argument. Counsel, let me advise you that these matters are being audio and video recorded, and there is a link to these proceedings on our court's website. So I want you to be aware of that as you make your arguments. Please identify yourself and your client when you make your comments and when you commence your argument. You both have 20 minutes. Counsel for appellant, you can reserve time for rebuttal. Just let us know. We have read your briefs. We've discussed the case. We've conferenced it. So we're quite familiar with the issues in your case. The clock and the podium in front of you will keep track of your time, and you may proceed. Counsel?
Good morning, Your Honors. Jimmy Barunda, attorney for the plaintiffs, the appellants. May it please the court. Your Honors, please let me comment briefly on the point we raised in our briefs regarding the Arizona Constitution. As stated in our reply brief, we do not contend that summary judgments cannot be granted in tort cases, only that on damage issues, every presumption is that juries determine the extent and amount of damages in Arizona. Our Constitution warns trial judges not to take such matters away from juries. And if there is any reasonable way that a jury may find for the plaintiff on a damage claim, it must be allowed to do so. And with respect to the emotional distress claim, Judge Foster stated my clients were not in the zone of danger and that they suffered no personal physical injury. Case laws applied to the facts do not support such a ruling. In regard to the zone of danger, this is a case where a drunk driver with a blood alcohol content level of 0.232, almost 3 times the legal limit, he crashes his car into a house at a very high rate of speed while everybody's asleep. The crash demolishes the small 3-bedroom house, and the drunk driver comes within inches of killing an 11-year-old boy sleeping in the bedroom. And the house gets flooded by shattered water pipes. The fact that the car didn't crash directly into my client's bedroom, that hardly indicates that the crash did not create an unreasonable risk of bodily harm to my clients.
Counsel, can you point me to any case that has injuries, such as the injuries that your clients are claiming in this case, such that they were sufficient either for a claim for negligent infliction of emotional distress or consortium? Can you name one case?
Yes, Judge, the Monaco versus Health Partners of Southern Arizona, under that case, purely physical injury to a plaintiff is not required if there is substantial long-term emotional disturbance.
You think go ahead.
I'm sorry, go ahead. I'm sorry, go ahead.
You believe the injuries are comparable in the Monaco case with what you've alleged in this case?
Yes, Judge.
Where in the record, in Monaco, Mr. Monaco suffered PTSD from the negligence, and long-term couldn't sleep, couldn't relate to his grandchildren, couldn't relate to his children, had a long-term incurable fear of developing cancer. Where in the record specifically do you provide evidence that the parents in this case, the parent, mother and stepfather, suffered equivalent long-term emotional injury?
Well, Judge, in the affidavit submitted by the parents state that they suffered emotional stress from the little boy, the 11-year-old boy at the time. He had suffered a scar, a permanent scar, a small scar on his leg.
Right, but what kind of long-term emotional distress did they say they suffered?
Well, also that the little boy was having nightmares after the accident.
I understand that. That went on for a short period of time, right? A year, 6 months, something like that. But what emotional distress did they suffer? Long-term emotional distress did the parents suffer based on their affidavits?
Well, that the little boy was having nightmares, and that the parents, the mother had to sleep with the little boy because he was having nightmares.
How long did that go on?
That went on for, I think, a little more than a year. And as a result of that, the parents hardly ever slept. They never even slept in the same bed because of that reason. And that was one of the reasons what contributed to the divorce.
So just to be clear, the claim, that the emotional distress claim, that's for the parents' own emotional distress that they suffered from this incident, or is it the emotional distress they suffered in seeing what happened to their children?
Well, immediately right after the crash, the parents went to the kid's room, and they witnessed the kids screaming and yelling, and they were terrified. And obviously there was manifestations of fright when the parents witnessed all the kids' actions.
So it's a third-party claim. That as third parties, as parents, they witnessed the distress and shock that the children were going through, and that caused them emotional distress. That's the nature of the claim. I got that right?
Yes, and also that there was other problems too, because the mother told the husband to build a railing or to build some kind of wall in front of the house to prevent this from ever happening again. And the husband said that he couldn't afford it, he didn't have the money to do it, and he never did it, and that caused emotional distress.
I'm not following you. What?
The mother instructed the husband to build a railing or a block wall in front of the house to prevent this from happening again, and the husband never did it.
And that caused the wife or ex-wife to suffer emotional distress.
Correct, and also.
But that stemmed from the trauma that the children suffered, ultimately,
Yes.
right? That's the source of it?
Yes, and also as stated in the appellee's statement of facts, the mother had told the husband to sell the house and to move out to purchase another house, and the husband refused. That caused more emotional distress.
So it's like a domino effect. Is that what you're saying? That because they saw the emotional distress and the possible harm to the children, that led to the mother sleeping with the child, and then that led to the divorce, or that led to the mother insisting on a railing, and that led to the mother insisting the house be sold, and all of that led to the divorce. So it's like a domino effect.
Yes, Judge.
Is that what you're saying?
Yes, Judge.
Okay.
And it's important to point out, judges, that my client's bedroom was in such proximity to the children's bedroom that there was a very high risk that the drunk driver could have kept on crashing into their bedroom. So obviously, there was an unreasonable risk of bodily harm to my clients.
What was the loss of consortium claim? Is that the loss of consortium between the parents, or between the parents and the children, or both?
Well, under Arizona, there's a loss consortium between the parents and the children, and also between the spouse-to-spouse relationship.
And you're alleging both?
Yes.
Counsel, was that spouse to spouse, the loss of spousal consortium, was that raised clearly below in the trial court? Was that raised
Yes, Judge.
in your complaint?
Yes, in the complaint, and also in the affidavits that we submitted.
Okay.
Judge, it's also important to point out that their presence in the zone of danger was absolutely concurrent with a serious fear for their children's safety as well as their own safety. And the Keck versus Jackson case said that the test is whether the defendant has created an unreasonable risk of bodily harm to the plaintiff. And that test was easily met here. And also, as I pointed out earlier, in the Monaco case, that the court said that purely physical injury to a plaintiff is not required if there is substantial long-term emotional disturbance. And certainly the emotional stress my clients suffered from finding their home destroyed and actually witnessing the kids screaming and crying and that their lives were endangered immediately after the crash, that justifies a jury to be impaneled to determine their damages. And with respect to the loss consortium claim, Judge Foster, he granted a summary judgment because he said the record shows no permanent physical disabling injury to the kids. That is factually true, but that is not a basis for throwing out the claim. Under the case of Barnes versus Outlaw, there is no requirement that each person in the loss of consortium equation must have sustained a physical injury. According to the Barnes case, when there is a question about the merits of a loss of consortium claim, the court should rely on the fact finder to determine the legitimacy and extent of any alleged damages. Please keep in mind that there are two bases. As I stated earlier, there's two bases for the loss of consortium. One is the parent and the child, and the other one is the spouse's spouse. The extremely drunk driver crashing his car into the house not only damaged the parent-child relationship, but it also led to my clients getting divorced, as I stated earlier. And under the Arizona Constitution, my clients have a right to present that contention to a jury. As I admitted in my briefs, proving damages in a case like this may be an uphill battle because of the lack of anyone being seriously injured. But trial judges in Arizona are just not permitted to make that judgment themselves. They must allow a jury to decide such issues.
Are you suggesting this is just an absolute right to present damage claim? I mean, isn't this governed by the motion for summary judgment standard? Is there a genuine factual dispute or not regarding causation? Can a judge in a motion for summary judgment context say there is no genuine dispute, there is no causation, and grant summary judgment? The Constitution doesn't preclude that, does it?
No, but the Constitution affords citizens a right to present any damage claims to a jury.
No matter what?
Any damage claims to a jury, the legitimacy and the extent of the damages to a jury.
What if there's insufficient evidence to support the damage claim? Then the judge could grant a motion for summary judgment or a directed verdict, right?
Yeah, I agree, Judge. If there's insufficient evidence, the judge could grant summary judgment, but
That's not a violation of the Constitution, though.
no, that's not.
Okay.
But in this case, I believe that enough sufficient evidence was submitted with the affidavits that were submitted. Thank you for your consideration, Judge.
Thank you. Counsel?
Good morning, Your Honors. Neil Thomas and Brian Rubin on behalf of Flanders Rico. You heard the basics of the facts, and it's clear that you are well aware of exactly what occurred with regards to the physical activities of a vehicle going into a house. We've been complimented in the reply brief for trying to defend the indefensible, but in my view, there's really no claim. And the reason there's no claim is plain and simple. You're only being asked to review the record, in essence, whether there were sufficient evidence to meet the elements of the two torts that are here. Today is the first day we've ever heard about spousal loss of consortium. It wasn't raised, it wasn't briefed, it wasn't argued, it was never there. I don't know how I point to a record to tell you that it was waived, but I can tell you it's not there. If the suggestion that the husband and wife are being divorced is sufficient to raise spousal loss of consortium, that's about as close as you can get. And what I heard when we talked about the domino theory a moment ago was really a Paul's graph defense, which would be obviously made if we were getting that far. Now, let me tell you what this case is not about. It's not about whether somebody was damaged or whether there was an unreasonable risk of harm to somebody. We're not on to the damages side. We are talking about the components of two torts. The loss of parental consortium because of the injuries to the child, and then bystander negligent infliction of emotional distress. I don't have much to say on the bystander case because on the record in the court, Mr. Berenda recognized and stipulated on page 26, I believe, of the oral argument transcript that there's no evidence of any physical manifestation on the parents. That ends it. But there's 3 words for the negligent infliction of emotional distress. Witness something, zone of danger, physical manifestation, actually.
Not
4
Monica.
words. Monaco is a direct injury to the plaintiff. That's it. It's talking about the plaintiff who had been involved in certain activities directly with the defendant. It's just a typical tort case in which somebody did something allegedly wrong, emotional anguish is there, a lot of symptoms. There's one of the cases, I don't remember off the top of my head, where somebody had chattering teeth, and ground teeth at night. But that's because the injury, the effect was to the plaintiff. This is bystander negligence. That's why the 3 components are there. In fact, not long ago, I think in 2009, the Kaufman case was decided in which somebody wanted to claim because their pet had been, and Roman versus Carroll, because of damage to a dog on a leash by another dog. The idea that you have an upset about something doesn't mean you have to have coverage. That doesn't mean you have to have a tort coverage. You have to have a tort coverage area in the context of, did they witness it? Were they in the zone of danger? And is there a physical manifestation? The record contains no affirmative evidence for any of these 3 components and affirmative evidence from the plaintiff's counsel themselves that there's no physical manifestation. So if this case has any close connection to any tort, which we concede it doesn't because it wasn't very hard to defend the indefensible in this case, is the parental loss of consortium claim. And the Villarreal case is child for parent, and the Pierce case is parent for child. And they both make the same basic assertions as to how we limit this derivative claim. First off, there has to be a severe, permanent, and disabling injury somewhere. Now, I thought I heard some confusion as to whether that severe, permanent, and disabling injury in the questioning had to apply to, in this case, the children or the parents. The parents are bringing the claim for their loss of consortium with their children. The children have to have had a severe, permanent, and disabling injury. There isn't any evidence of that. You heard that the permanent injury is a abrasion with a scar. I don't think that reaches the level of severe, permanent, and disabling. And the Pierce case and the Villarreal case both say that there is, unlike in many other direct cases, this is a derivative case, there's a judicial threshold to determine precisely whether it goes to a jury on whether there is to be any recovery and what the amount of recovery would be. In fact, Judge Vosser was quite keen about how this is slightly different in this derivative area. And frankly, I'm probably wasting my breath because if you read his 26-page oral argument thing, you probably would be convinced that there's no case here, because he had it down the analytical basis for this particularly important. The next question.
Counsel, before you move on.
Sure.
Did the children suffer psychological injuries?
I suppose you could say
there was the Barnes case, okay, that the counsel referred to, because I seem to read that case.
that case talked really about whether there was physical injury, and it was only talking about one component.
It says the purpose of the consortium claim is to compensate for the loss of these elements, which can certainly result from psychological injury as well as physical harm.
But there must be the physical harm, and there must be psychological injury. When that would be fine if it was for the kids, and the kids brought their case, and as you know, that case was all settled and taken care of. This is the parents' case, and we can't confuse the parents' case with the children's case. And in fact, they were very clear in the Pierce case that we have to be very careful about negligent infliction of emotional distress, where you got to be there, and we have to look at the loss of consortium claim, which is derivative. But even if you wanted to assume that a scar on a leg and some sleepless nights for a child was some level of injury, it's not severe, permanent, disabling. The records that were before you show how transitory it was. Most importantly, there has to be some interference with the parent-child relationship in a normally gratifying way. That's the second threshold level. Dr. Holzman, in his medical records and his later submitted affidavit, which wasn't considered by the trial court in summary judgment, and we don't believe considered at all, because it was a dismissal of the motion for reconsideration. Never in any of the documents before you, inadmissible, not admissible, and we're not going to make a big deal over the procedural aspects of the summary judgment, never talked about the relationship between the parents and the children and how it was in any way not a normal situation. In fact, one could argue that mom was overly concerned and overly sheltering for these children and had a very good relationship and a close relationship with them. And that's the best evidence you have. And again, we have the threshold decision that judiciary makes before we go running off to court for anything. And I think what you've heard is really, oh, my client's home was destroyed, people got hurt, I get to bring an action for anything I want because there's a dispute as to how much money I should get for damages. But tort law doesn't work that way. And in order to be clear, we don't want to confuse the two torts that are before you. Both of these torts require threshold analysis. They both had threshold analysis, and they both failed. You know, it's not one of those things where we can argue about three elements are in, one element might be close, you didn't make the element, you're done. No elements of any of these two torts exists. There wasn't a severe permanent disabling injury that interfered with the parent-child relationship in a normal, gratifying way. For consortium, there was no witnessing, no zone of danger, no physical manifestation of the parents for the bystander claim. And with that, if you have any questions, I'll be happy to sit them. Otherwise, I'll sit down and listen to the plaintiff finish their time out.
Any questions? No?
Thank you, Your Honor.
counsel. Rebuttal?
Thank you, Judge. Judge, under the Monaco case stated that a physical injury wasn't a permanent physical injury wasn't necessary, that emotional disturbance was sufficient.
Do you have a case that applied Monaco to a bystander situation? I mean, Monaco wasn't a bystander situation. Plaintiff was the patient of the hospital. Here we've got a bystander situation. Do you have a case that applied the Monaco, you don't need a physical injury as long as you have a long-term emotional disability, emotional harm to a bystander case?
No, Judge. But actually, this isn't really a bystander case because the parents were in the zone of danger. The drunk driver could have kept going into the parents' bedroom. So it's a borderline of whether it is a bystander case, because the drunk driver could have wrecked into the bathroom where there's a hot water heater, and he could have ruptured gas lines. Okay. So, but other than that, Judge, you have any questions? I'll sit down.
Any further questions? No. All right, thank you, counsel. We'll issue a written decision in due course. We'll take the matter under advisement. Court's in recess.
on your way now to reconferencing. I can ask the clerk to see whether or not they can do, or if they can do, I'm not sure how long. They'll post-conference both cases after hearing oral argument, so I can, I'll go ask the clerk, and see if they can.
Hey, can we also get a copy of the court docket if they have the entry?
Yeah,